Okay, well, welcome to this talk on data breach responses. I'm Tom Llewellyn. I'm a partner in the commercial litigation team here at Ashfords and a member of the data protection team. As again, just for anyone who has joined since I said, please can I ask everyone to mute their microphones, but also a reminder that this session is being recorded. So thank you. We have a 30-minute slot today, and there's a lot to cover. So I'm unlikely to have any time for questions at the end. But if you do have any questions, do feel free to contact me using the contact details in this slide, and which can also be found on our website. So responding to data breaches. So the focus of today is on the fundamentals of responding to a personal data breach. There are wider issues such as defending damages claims arising from data breaches or responding to ICO investigations, but those will be a topic of future webinars, and it's really just too much to cover in a half-hour slot. But I'll start with looking at what a data breach is and the various steps that need to be considered when responding to a breach, including a breach risk analysis, notification to the ICO, communications to data subjects, and the steps you should take to rectify and mitigate the breach. And then as a final point, I'll just touch on risk management considerations, which are necessary and important to ensure that an organisation can actually adequately respond to a data breach. And we're going to look at data breaches today as on their own, as distinct from, for example, a cyber attack, which rightly necessitates additional considerations. It's definitely true to say that not all data breaches are cyber attacks. Human error, for example, sending out a letter to the wrong addressee is a data breach, but wouldn't be a cyber attack. And similarly, not all cyber attacks are data breaches. Denial of service attack would not be, for example, albeit it's quite often a ransomware attack would be a data breach, given that personal data will likely be compromised in some way. A preliminary point to consider at the outset is, why do we need to respond to data breaches properly and adequately? The fact that you're here listening to this webinar suggests that you're well aware of the implications of not doing so. But notwithstanding, a primary driver is the regulatory obligations that organisations are subject to, as well as it being the right thing to do to safeguard the rights and to protect the information or the data subjects that you hold information on. If you don't respond properly, then you can face a fine from the ICO, which can be significant, up to 17.5 million, or 4% of worldwide turnover. But in addition, failing to respond properly can increase the potential damages claim that you may face from an affected data subject arising from a breach. It's probably well known that there is, unfortunately, a growing claims industry that will seek damages for any loss suffered as a result of a data breach, even if there's minimal loss, and will also try to claim significant and disproportionate costs. They will seek to expose any failure to respond adequately to a data breach, and therefore it's really important to do so to mitigate the risk of any such claim arising, or to give you a defence to any such claim. So the first point to consider is, what is a data breach? Well, it must relate to personal data, which seems obvious, but it is an important starting point. Now, personal data is defined as information relating to an identified or identifiable natural person, the data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as name, ID number, location data, an online identifier, or one or more factors specific to physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. And then, as per Article 412 of UK GDPR, personal data breach is then defined as a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure, or access to personal data transmitted, stored, or otherwise processed. Now, it's important to note that it's not just the unauthorized disclosure of or access to personal data that constitutes a data breach. It also covers unlawful destruction and loss. This is a point which often gets forgotten. But for example, a ransomware attack where personal data is encrypted by the threat actors but not extracted would still be a data breach because access to it has been lost. However, and as we'll soon see, such a scenario may mean that the threshold for reporting to the ICO and communicating to affected data subjects is not met in such a scenario. This does not, however, mean that you should do nothing in response to such a scenario from a data breach or from a data protection perspective. So what are the immediate considerations following the discovery of a data breach? Now, once the breach has been identified, there are 3 steps that should be carried out. First is to shut down the data breach if it is continuing. The second is to carry out a risk analysis and investigation. And the third is within 72 hours of discovery, if the threshold for reporting is met, to report the matter to the ICO. Now, quite often, steps 1 and 2 will involve a detailed analysis of the nature of the breach and the extent to which any personal data has been misappropriated. In the case of severe breaches, this will require your IT team, third-party forensic IT experts to identify the scope of the breach, the affected data subjects, and the nature of the breach that's been affected, as well as then looking at the risks that can arise from that data being in the wrong hands. There are various experts out there and a number that we work with regularly who can assist in that process. But such an exercise can and often does take longer than 72 hours for severe data breaches. However, that is not a reason not to provide an initial report to the ICO if the threshold is met. It's also worth noting that the 72-hour time period does not pause. The breach discovered at 12 p.m. on a Friday will have to be reported by 12 p.m. on a Monday. Time does not pause over weekends, outside of working hours, or over bank holidays. So in that example of a breach discovered at 12 p.m. on a Friday, you actually have just 1 working day to investigate and analyse the breach. This really does reinforce the need to have sufficient data breach response plans and protocols in place so that you can respond adequately within the time period, even where that time period runs over a weekend or a bank holiday. So once you've completed your investigation, you need to consider whether it needs to be reported to the ICO. Now, your obligations as a data controller in this regard are set out in Article 33 of UK GDPR, and they require 1, a report within 72 hours of becoming aware, as we've already said. That's unless data breach is unlikely to result in a risk to the rights and freedoms of the data subject. Now that's the key test, the threshold. So if it will result in a risk to the rights and freedoms, then you must report it to the ICO. If it's not possible to notify within 72 hours, this must be explained when notice is given, and there's a list of specific information that must be provided in Article 33, which is describing the nature of the personal data breach, including, where possible, categories and a number of data subjects concerned, and the data records concerned, communicating the name and contact details of the data protection officer or another point of contact, describing the potential consequences of the personal data breach, and then the measures taken or measures proposed to be taken to address the breach, including any steps to mitigate the adverse effects. Now, if you do not deem the data breach to meet the threshold, if you do deem the data breach to meet the threshold, then the ICO has an online form which provides information it requires and covers all of the requirements of Article 33. So that is the medium through which you report to the ICO. You can also report to the National Cybersecurity Centre or Action Fraud, but that's really more relevant to cyber attacks than a straightforward data breach. As stated, it's often not possible to complete investigations within 72 hours. In such circumstances, it's very common to provide a preliminary report and then a further report. And it's important to note in this regard that there's no time limit for further reports, just as and when that information becomes available. So if you do get the initial reporting within 72 hours, there is a lot more time to then carry on with investigations and follow up. My advice in this regard would be to err on the side of caution. If you're unsure whether a breach meets the threshold, that is not a justification for not reporting. If there are ongoing investigations which will clarify that, you should notify, and then within the 72 hours, and then you can send an update subsequent to this, which provides additional information and might state to the ICO that actually, following these further investigations, do not deem the breach does not reach a threshold, and it did not actually require reporting, and therefore you not also intend to communicate to data subjects. Hopefully, if the ICO agrees, it will simply close the matter. But that's a much more suitable approach and a safer approach than providing a report significantly after the 72 hours has expired. Now, a common concern for clients when considering the need to notify the ICO is where they have customer contracts which require notification in the event of a reportable data breach. This quite naturally and obviously create a hesitancy to report to the ICO either at all or whilst investigations are ongoing. But the simple point is that really this should have no bearing on whether a matter is reported. If the threshold is met, or you think there's a risk that the threshold will be met, then the report should be filed and notification should be given to the ICO. It may be the case that the wording of the clause in your contract can justify not providing notice to the customer whilst an investigation is ongoing, but that really would depend on the relevant contractual wording. It really is a point to consider when drafting and negotiating commercial contracts that put an obligation to notify in the event of a data breach. And a final point to note is that even if you have a breach which does not require reporting, you still have to carry out an analysis to justify the non-reporting, and it's the same analysis that you would carry out, and then you should document this and still take remedial action if possible. So even if it's not reportable, it doesn't mean you should take no steps in respect of the breach. And the log should cover all of those points for future reference. Again, whilst it's a regulatory obligation, it's also important, should it later become more widely known and either the ICO investigate or you receive a damages claim arising from a data breach. Certainly the ICO and the claim law firm may want to see a copy of this, but it may also help your position when dealing with both. So what do we mean by a risk to the rights and freedoms of data subjects? It's quite a high level and vague phrase, but really it's a factual test. Helpfully, the ICO has a 5-minute and 5-step self-assessment tool available on its website. Now, this asks about both whether there is a risk and a high risk to data subjects, and then gives the following definition, which is the risk exists when the breach may lead to physical, material, non-material damage for the individuals whose data has been affected or breached. Essentially, is there a risk of harm in some way, whether it's physical, financial, or other type of harm? Now, the distinction between risk and high risk is really relevant to whether you need to communicate with data subjects, and I'll touch on that in a second. But there's little guidance on what constitutes a risk to rights and freedoms. It's really a factually specific test for each individual circumstances, but the ICO helpfully provides some examples with indicative reporting decisions. So, for example, case study 1 was a failure to redact paperwork sent to birth parents without redacting the names and addresses of adopted parents. Now, in that scenario, it was reportable and notifiable because of the risk of harm to the adopted parents and the adopted child for self-evident reasons. Separately, case study 2, emailing a file in error containing a vulnerable person's financial information. Because in that case study, the information was sent internally, it only required internal logging and documenting. But if it had been sent externally and wasn't possible to remedy it, so for example, emailing the recipient and obtaining confirmation that it had been deleted, then it may, depending on the nature of the information, tip the threshold to require reporting to the ICO. Again, if you can remedy it, then even if it would otherwise tip the threshold, that justifies non-reporting. Again, case study 3 that the ICO give is a lost laptop with personal data on it. Now, in this instance, you may think that it would immediately be require reporting to the ICO and potentially notifying affected data subjects. But if the data is encrypted, which we would hope most laptops are, there's no need to report or notify it. You just have to log the data breach. Again, this would slightly depend on the nature of the personal data in question. If the laptop wasn't encrypted, so for example, business contact details, whilst clearly personal data meets the definition of personal data, the risk of harm threshold would be unlikely to be met in that scenario because it is simply business contact details, whereas private contact details and further information could result in harm to the individual. There's obviously with business contact details, if it's just contact details, there's probably no wider risk. If it's business contact details and passwords, there might be a risk that does justify reporting and notifying. And a fourth case study given by the ICO is a phishing attack resulting in compromised internal email accounts involving financial information relating to a data subject. Again, in this instance, there was the ICO states that this is reportable and must be notified to data subjects as there's a clear risk of financial harm. What's important to note and what I hope comes out from those case studies is that the concern is not really volume per se, but risk. And if there's a risk for just one individual, this is sufficient to justify and require notifying the ICO. And in this regard, any special category data clearly increases the risk, and therefore is likely to result in a need to report to the ICO unless the risk can be mitigated. By way of a reminder, special category data is data that concerns racial or ethnic origin, political opinions, religious or philosophical beliefs, or trade union membership, and the processing of genetic or biometric data, or data concerning health or a person's natural sex life, or sexual orientation. So, turning now to your communications to data subjects. Article 34 of UK GDPR sets out a data control's obligations in this regard, and that states that communication is only required where the breach is likely to result in a high risk to the rights and freedoms of the data subjects, which is a higher threshold than the requirement for notifying to the ICO. You've probably seen that if you go onto one of the many websites that can tell you whether you have been subject to a data breach, then you will see your contact details and multiple data breaches that you weren't aware of. I did that this morning for the purpose of this talk, and can see that my details have been involved in twice as many or a number of data breaches that I wasn't aware of. It's certainly worth doing as an exercise to really kind of reinforce the difference between the notification requirement and the communication requirement. But what does high risk mean? Again, it's probably slightly unhelpful to say that it's factually dependent, but it typically means password or financial information or medical information or other form of special category data that's going to cause significant harm to the individual. So whether it's a financial loss, or in the example where the ICO gives in its first case study involving adopted parents' names being given, an individual being given the opportunity or the chance to communicate and contact the adopted parents and potentially cause harm in that regard. And then in terms of what has to be communicated to data subjects, if the threshold is met, the communication needs to describe in clear and plain language the nature of the personal data breach, and at least the name and contact details of any data protection officer you have, or another contact point where more information can be obtained, a description of the likely consequences of the breach, and a description of the measure taken or proposed to be taken to deal with the breach, including any measures that the data subject themselves can take to mitigate any possible adverse effects. So this might include forcing a password reset, advising individuals to use strong or unique passwords when doing so, telling them to look out for phishing emails or fraudulent activity on their accounts, or advising them to change passwords for bank account details. Again, it depends on the circumstances, but when you carry out the risk analysis, you will be able to look at and consider what would be appropriate in the circumstances. Again, Article 33.3 does state that no communication is required in certain circumstances. That's point A is, are there sufficient certain security measures in place that render the data unintelligible to anyone without authority? So, for example, encryption. This is a factual test, but must be carefully considered, especially given the tools available to hackers and threat actors who may have taken that information. If you think they have the ability to get around the encryption, then clearly there's still a need to notify data subjects. Point B is subsequent measures have been taken which ensure that the high risk is unlikely to materialise. Again, this goes to mitigation, which I'll touch on next. But if a data breach has been remedied, then there would no longer be a high risk, and therefore no need to communicate this to data subjects. In light of the PR implications of publicising data breaches, which I know many organisations or all organisations will naturally rightly be concerned about, this only reinforces the need to seek to remedy the breach immediately or as soon as possible, and ideally before the need to communicate to data subjects arises. And point C, justifying non-communication, is if it would involve disproportionate effort, in which case public communications can be used as long as the result is equally effective. In most cases, this won't be relevant. Typically, a company will have contact details for all affected data subjects and will be able to email them direct, but it might apply if contact details have been lost or are currently unavailable as the result of the breach. But otherwise, where contact details are held, even a mass email to all affected data subjects will be expected. And the final point to note is when providing a report to the ICO or providing an update to the ICO following the initial report, you will have to communicate whether or not, or inform the ICO whether you have taken the decision to communicate to data subjects, and if not, why not? And if the ICO doesn't agree, it retains the power to require an organisation to communicate. So, turning now to mitigation, really we're talking here about the steps you take immediately following the breach to shut it down, but also any subsequent steps that may be taken to mitigating the risk and recovering the information which has been taken. The first point to note is if the breach can be fully or partially rectified, you must take whatever appropriate steps there are in line with your ongoing obligations under GDPR, in particular to ensure that any data held on in respect to data subjects is secure. So if it's, for example, information has been posted on a website or a portal has been left open with a security flaw, fix that immediately. Sometimes you might think it's an impossible task. For example, in a scenario where hackers have misappropriated data, and it might well be, but quite often there's a technical solution to prevent the breach continuing, and that should be investigated and considered as part of any response plan. Equally, if information has been sent out incorrectly, for example, a letter sent to the wrong person or the wrong attachments, consider obtaining undertakings to confirm deletion, or in the most extreme cases, getting an injunction to prevent the further distribution of that material and to recover that material. The steps that are necessary will vary enormously depending on the breach in question, but these types of action should be considered. There will be some cases where it isn't possible to recover the information, but the cause of the breach should still be rectified where possible. And again, it's worth highlighting and reiterating that any failure or delay in taking these steps to mitigate can have consequences both with the ICO and increasing the harm suffered by data subjects that may subsequently result in a higher damages claim if a damages claim is made. So I'm just coming onto the last slide now, which is risk management, and the final point to touch on. It goes without saying that you should have appropriate training, protocols and security measures in place to prevent a breach. I'm not going to touch on that now. What I'm going to focus on, what's often forgotten about, is having sufficient training and protocols in place to adequately identify and respond to a data breach. Really, what we are talking about here are proactive steps taken to put in place plans and procedures. So, the first key should be staff training to recognise and report a breach, as well as having appropriate reporting methods, whether it's a hotline or an email account that the staff can email. Following this, there needs to be a dedicated team to respond and organise the breach response. So, and that team would then have in place specific plans and procedures to rectify the actual breach in question, engage third-party experts where necessary, escalate where necessary, and then undertake the correct risk analysis as to whether they have to notify the ICO and communicate with data subjects. This will, what any data breach response plan and procedure will look like will depend on the organisation and the categories of breach, but should, as I've said, should include external experts who can be contacted following an incident. And by this I mean lawyers, IT experts, and even PR experts. Having an agreed panel will help you respond quickly and help to maximise the chances of reducing any risk to data subjects within that first 72 hours, rather than using that 72 hours to actually search around and locate experts who can assist. That 72 hours really needs to be reserved for the investigation, mitigation where possible, and carrying out the risk analysis and, if necessary, reporting to the ICO. Worth highlighting at this point, because I don't think I've said it, 72 hours is just for reporting to the ICO. The communications to data subjects does not have to be within that 72-hour period. And as I say, the exact breach response plans will be different for each organisation and each level of incident, but it's absolutely necessary. And that's what has a panel of experts that we can utilise in response to a breach, but it's better for clients to have their own agreed panel as part of their own respective response plans. Again, if you don't have adequate response plans in place and therefore fail to respond adequately to a breach in line with your regulatory obligations, then this could result in a fine from the ICO and an increased damages claim. Finally, from a risk management perspective, the data breach log that you are required to keep in respect of any data breaches that occur, that even including those that don't have to be reported, will serve as a useful record of incidents and will help identify any technical or training needs within the organisation. So again, rather than simply being a regulatory obligation, that's something that can really help an organisation identify where it might have weaknesses and what any steps it needs to take or could take to prevent future data breaches occurring. That brings us to the end of the webinar with a minute to spare. So thank you for listening. I hope everything I've said was helpful and give you some food for thought. There isn't time for questions, unfortunately, but please do contact me directly if you'd like to discuss anything I've said, and I'd be happy to talk to you about any questions you might have. Thank you again, and I hope you enjoy the rest of the day.